awor. So in the previous episode, we were introduced to Mr. Martin Kioko. Mr. Martin Kioko went through the process of redundancy. He saw that it was unfair and he was able to seek the services of a lawyer. So before we get into how the lawyer built the case, how the lawyer structured his arguments, we have to understand the judicial system in Kenya. So the judicial system in Kenya is under common law. So we inherited this system from the British who colonized us. Common law system means English law that has been derived from customs and traditions that have been built over time. Judges and magistrates in Kenya are obliged to make their rulings and decisions as consistent as possible using previous judicial decisions. For my learned friends, this is the doctrine of stare decisis, which loosely translates in English as standing by decided matters. For my lay friends, it is important to note that the significance of common law is justified as to provide predictability, stability, efficiency, and fairness in law. So anyone who wants to bring in a legal action before the court will know the outcome beforehand. So lawyers are able to advise their clients using settled rule of law. So that being said, let's now jump into the practical case as we had seen in the previous episode. So Mr. Martin Kioko, we've seen that he was very upset. He saw that the redundancy was unfair, and so he sought the services of a lawyer. So when he went to the lawyer decided to draft on his behalf a statement of claim. A statement of claim is a document that you file in court to institute a suit in the Employment and Labor Relations Court. It is important to note that the Employment and Labor Relations Court is a special court that deals only on employment matters. And for you to start a case or to institute a suit in the Employment and Labor Court, you have to start it with the statement of claim. The statement of claim is where you write, the lawyer would pose his arguments, and also at the end would seek for prayers or reliefs that he would want the court to grant him. In return, the defendant, who is the responding to the statement of claim, in this case, which it will be Twiga Logistics, the Twiga Logistics will file a memorandum of claim. So here is where they will be saying that whatever arguments that the claimant has put across, they don't agree it or they can counter the argument. So in the statement of claim, Mr. Kioko avers that Twiga Logistics unfairly terminated him. And he wrote his reliefs that he wanted the court to grant him. So the first one was a declaration by Twiga Logistics that they indeed unfairly terminated Mr. Kioko. The second one is a declaration to show that Mr. Kioko was discriminated against. The third was one month's wage in lieu of notice. Fourth is compensation for unfair termination. Number 5, interest in number 3 and 4. Number 6 is damages for discrimination. Number 7 is the cost of the suit. And number 8 is any other reliefs that the court deems fit to grant. So according to Mr. Kioko's lawyer, Twiga Logistics did not comply with Section 40 of the Employment Act. As we had seen before, Section 40 of the Employment Act outlines the conditions and the procedure that an employer needs to follow before terminating an employee's services on account of redundancy. So Mr. Kioko's advocate relied on one of the decided cases, and in that particular case, a judge had stated the importance of following the conditions set out in law. So the judge held as follows. The conditions outlined in law are mandatory. It is not up to the choice of the employer to follow or not to follow. Redundancy affects workers' livelihood, and if at all it must be done, an employer needs to follow the black letter of law. The lawyer further relied on another case. In this particular case, the judge stated that when an employer declares an employee redundant and the said employer does not follow the conditions that are set out in Section 40 of the Employment Act, then that particular termination becomes unfair termination under Section 45 of the Employment Act. We shall look at Section 45 in another series. As of now, let's just continue. So the first condition that Mr. Martin Kyoko's lawyer alleges that Twiga Logistics did not comply with was the condition on notification. So we were able to observe that Twiga Logistics communicated to the Labour Office on the 25th of August. In that particular letter, they stated that similar communication will be done to Mr. Martin Kyoko by the 25th of August, and that the termination of his employment will be effective by the 30th of September. Unfortunately, no communication was done to Mr. Martin Kyoko as it was stated in the letter. Communication was done on the 4th of September. There was no simultaneous communication. Therefore, this went against the provisions of Section 40. So the provisions of Section 40 require that communication be simultaneous. If the communication is not simultaneous, then Section 40 on the part of notification was not complied with. The second condition that Mr. Martin Kyoko's lawyer alleges that was not complied with by Twiga Logistics was when it comes to the spirit of Section 40 of the Employment Act and Section 56 of the Labour Relations Act, and that is consultation. So Section 40 of the Employment Act provides that where an employee is part of a trade union, the notification on his termination on account of redundancy should be done to the union and not to the employee directly. Also, Section 56 of the Labour Relations Act provides that officials of the trade union are entitled and are free to go to the employer's premise and have conversation with the employer, consult with the employer on any issues and dealings with the employee. This is reiterated in the ILO Convention. The spirit of these two statutes, these two provisions, is that consultation is mandatory. That being said, we were able to see that Mr. Martin Kyoko was called into a meeting. In that meeting he was told why he's being terminated. The HR was told him about his terminal dues, and he was given a letter. That was it. There was no consultation. Consultation is implicit in both Kenyan law and ILO conventions. In one of the decided cases, one judge stated that consultation is mandatory to mitigate the adverse effects of termination on account of redundancy. And also it is a way where both parties can sit down, have a discussion, and maybe find a way for not actually terminating the employees. In another decided case, one judge also said that redundancy is not a one-day process. It must be participatory, consultative, and informative. The third condition that Mr. Martin Kioko's lawyer alleges that Twiga Logistics did not follow was the condition on the selection criteria. So Twiga Logistics filed a bundle of documents. In that bundle of documents was a statement from the finance manager. In that statement, the numbers showed that the air freight department had been getting losses way before Mr. Martin Kioko was hired. Mr. Martin Kioko was never given a reason on the criteria for choosing him specifically. Section 40 of the Employment Act provides that an employer needs to take due regard of the employee's seniority in time, his skills, ability, and reliability. This is before he decides to terminate him on account of redundancy. Mr. Martin Kioko was not given any reason or criteria as to why he was chosen specifically. In one decided case, one judge stated that where a redundancy selection criteria is not clear or non-existent or opaque, the statutory threshold cannot be said to have been met. According to the lawyer, Twiga Logistics selection criteria was not objective and it was not open. Hence, it did not meet the statutory threshold envisaged under Section 40 of the Employment Act. In Mr. Kioko's statement of claim, he prayed for compensation because, according to them, the conditions of Section 40 were not met. Therefore, the termination on account of redundancy was unfair. In another decided case, one judge stated that in considering the quantum of compensation, the relevant factor to be considered is the difficulty in acquiring alternative employment. According to Mr. Martin Kioko's lawyer, Mr. Martin Kioko was having difficulty in acquiring alternative employment. Unfortunately, he did not give any evidence to show that Mr. Martin Kioko was having difficulties. So these are the arguments that Mr. Martin Kioko's lawyer brought before the court. Tune in to the next episode where we'll be looking at how Twiga Logistics built their case and how they responded. Thank you so much for joining me today. Remember, haki iwe ngao na mlinzi.